tested. The lessons we learned last year was the quality of information, the timeliness of information was lacking for us to do that orderly administration. That's just my take on it. I think those are valid questions, and that we do need to continue to communicate, these type of intents. But I think it's important that we respond in a fashion that mirrors our findings of emergency. So I want to honor that comment.
Ms. Ackroyd, followed by John Herrick from South Delta Water Agency. Hello.
Good evening. Excuse a bit of laryngitis. Rebecca Ackroyd for Westlands Water District. My comments are going to build slightly on John Rubin's comments that were made just a little while ago. As John pointed out, in July 2014, when the precursor to the present regulation was enacted, it was paired with an emergency regulation that allowed the board to issue curtailment orders. Right now, there's no similar curtailment order regulation being proposed. However, as John also stated, there's existing authority that allows the board to investigate and stop illegal diversions. Westland's comments today to encourage the board to be prepared to utilize that authority, either existing authority or authority under new emergency regulations to stop illegal diversions. Separate and apart from the proposed emergency regulation regarding information orders, the board has the ability to undertake investigations to determine whether a water use is illegal. And Section 856 of the board's regulations require the board to investigate allegations of misuse of water. And I think going back to what was said earlier, it's talking about allegations. No complaint is required, but investigate allegations of misuse of water. Past investigations, the board has the ability to take immediate action to stop illegal diverter, whether the diverter claims riparian or appropriative right. Water Code Section 275 requires the board to take all appropriate proceedings or actions before executive, legislative, and judicial agencies to prevent waste or unreasonable use. So together, the Water Code and board regulations require the board to both investigate and take appropriate proceedings to stop illegal diversions. Although typically the board has used CDO and administrative civil liability as the tools to accomplish this end, as John stated before, Section 1052 provides another even more important tool in the present drought, which is immediate referral to the Attorney General to institute actions for injunctive relief. And that enables the board to request the Attorney General to have an action for a temporary restraining order, preliminary injunction, or permanent injunction for any unauthorized diversion or use, including a violation of a board order or decision. We believe it's critically important that the board be prepared to take immediate action to stop illegal diversions. While the board must do so in a way that respects due process, the action must be swift. We believe taking swift action this year will put us in a better position for later this year, for next year if there's continued drought, and for future droughts. If the board does not plan on using its existing authority under Section 1052 or other provisions, then we would request that the board consider adopting new emergency regulations that would give the board additional authority to do so. Are there any questions? All right.
Thank you.
Thank you.
Very much. Mr. Herrick, followed by Mr. Nomalini from the Central Delta Water Agency.
Good evening, ladies and gentlemen, Chair, Lady, and members. John Herrick for the South Delta Water Agency. Thank you very much. I won't say deja vu all over again, but here we are, the fourth year of a drought, emergency regulations at the last minute in order to address problems, which is not the way to handle things. I think everybody would agree with that. Last year we made comments, and I'll just say them briefly again, dealing with the due process issues. We all have serious concerns that a expedited, truncated process that would fine somebody for not responding within a short period of time actually turns out to substitute for an evidentiary hearing determining somebody's water rights. So I don't know how the Division of Water Rights is going to make a decision that somebody is or isn't worthy of a cease and desist order or something else in a 30-day period after somebody's only had that much time to provide information, but that's our complaint from before. I would like to join in the comments of Ms. Spalletta and Ms. Zalesi, and I want to focus on one issue, and that was touched upon by staff, and that deals with the what complaint might start an investigation. The reason that's important is we've already gone through this. There are two issues. It's either a water right or a water availability issue for purposes of you going after them during the drought. Now, for water rights, I think everybody remembers back in 2009 and before, where the general consensus was to slander my clients in public and say they were all illegal diverters, and we had legislation saying they were all illegal diverters, and appointed a water master in order to investigate only my clients and not other people. And the water master did 3 or 4 years of investigation, and we spent hundreds of hours and thousands of documents and lots of meetings, and the water master prepared, that I saw, 2 reports or 2 updates that be presented to you, which said, goodness, we just wasted all our time and money. It appears that there are a few issues, and we're pursuing those few people, and it appears that everybody else has sufficient water rights. So the notion that you need me to spend another 1,000 hours to give you more information on the Delta water right diverters seems odd at the very least. Your process has already made that initial threshold determination for purposes of pursuing somebody, I think. Now, maybe you don't trust your prior water master, maybe somebody threw away his boxes, I don't know, but we already went through that. And so I don't see what the purpose is to have an expedited method by which to make me work overtime that I don't get paid for, even on St. Patrick's Day. So I have no concerns. The second area deals with the supply. Now, I'm not going to get into that now, but we have the issue. We've gone through this before about whether or not the Delta always has water. We think we've showed you that when you don't have releases, when you don't have stream flows, there's water in the Delta. It slowly degrades. Are there obligations to protect water salinity, water quality, excuse me? You know, all those things, those are, I guess, valid points of disagreement. We think it's pretty clear on our part, but that's a disagreement between the contractors or the state and federal projects and us. We think it's all pretty clear. So I don't know what you would do in the middle of that fight unless you're trying to fight for there being water surplus to the needs of the areas of origin or the Delta. This is the 4th year of drought. If anybody thinks there's water surplus to the needs of the North California, the Delta, I don't know what they're looking at, right? We can't meet our minimum standards, so there isn't any surplus water. So fighting on the edges there to see if somebody can be shut down in the Delta so that, 4 CFS is either released or not released from Shasta seems like a poor use of our time. Now, again, I think that's something between the contractors, the projects, and us. I don't know what purpose or benefit you guys would have joining in that fight, in that you would have to make these decisions based upon what we think is pretty clear. So I don't know. Anyway. I also wanted to say real quickly, the cost that you've done in the analysis for the thing is no offense, but horribly wrong. The notion that somebody would spend a short amount of time responding to a 30-day demand or request to provide evidence of a pre-1914 right is unrealistic, to say the least. We have other fights going on, as you know. Some of them involve hearings scheduled here, so I'm not going to get into that. But we spend years and hundreds of thousands of dollars, and people are out there reading, thousands of newspapers from 1880 through, 1914, looking for certain keywords. The notion that it's a small cost for somebody to comply with this is incorrect. I mean, it takes a long time, which again argues against this notion that you need an emergency regulation so you can demand something in 30 days. If you contact any diverter who's a single diverter, not an agency or an irrigation district, and you say, show me what happened on your land in 1893 or 1914, that takes a lot of work. There aren't documents that say, hi, I got up this morning, I applied water on 37 acres, and there isn't that information. So, I don't see what the purpose of this is. The board does need information. As you know, we've spent lots of time assisting you in gathering information, so I don't know why you need the threat against somebody to get it done. I'm actually here to express my disappointment that nobody's thanked us for all the work we did for that 94% compliance rate. It's higher than that because a couple of a number of the ones that add up to the 6% were statements that have been deactivated. So it wasn't a non-compliance. But anyway, to end with that stupid joke, we think the regulation is unnecessary. We need to have a process that deals with these things on a normal basis, not at the last minute. We cannot give you a complete history of a diversion upon 30-day notice. I thought I did that to a sufficient level with the last water master, and apparently it has no effect on the board's decisions now. So with that, I oppose the regulation. Thank you very much. And any extra time I took should come off from Dante's because of what happened last time.
And following Mr. Nomalini will be Terry Erlewine from the State Water Contractors. Hello.
I'm Dante John Nomalini. I'm manager and co-counsel for the Central Delta Water Agency. Without belaboring the point, I think your emergency regulations are an abuse of the emergency. I just restate that for the record because that's my feeling, that we have artificially created a situation here where the projects depleted the storage, created a situation where we don't have sufficient water to meet the standards. The standards have been set. You people have adopted emergency or temporary urgency changes to let them off the hook. And that's okay. The water's gone. And like I said before, I recognize that there's not a hell of a lot to fight over at this stage. Now, with regard to the emergency order, it seems to me that it's unnecessarily too broad in not defining what the delegation of authority is to the your staff. That any user could come in and say, hey, we do an investigation, and an emergency order can go out demanding information. Now, we are committed in the Central Delta and the South Delta to give you 100% response. Now, I don't appreciate the shortness of time of the notice and the lack of discussion with your staff beforehand, because we could have helped address this in a way that would make more sense. However, I want to thank them for making changes in the form so we could at least have our clients find it. And there was a concerted effort, and it helped us achieve the success that we have in providing the information. The other thing was we started trying to gather the database in September of last year, and we were fortunately able to get an index because the data is there, but how do you find it for an individual point of diversion? So, and I think I said it before, I sent one of my staff over to try and find this information or whatever. They stumbled into the State Lands Commission, and they were willing to provide an index for the Central and South Delta. I sure ordered it for the whole Delta because the database, I think, is for the whole state. Anyway, they wanted an immediate payment of $5,000. They gave it to them, and it took about over 2 months before we got an index. Well, it was that index that allowed us to be responsive to this short-term request. So don't think that that short-term would allow somebody else that didn't have the fortune of getting the index to provide you that information. Now, I think we're okay. We've given you patents. We've given you, that database has the certificates of purchase. It has the swamp and overflow surveys. Now, what you're going to do with it, and I cautioned everybody before that we have no problem trying to give you the information, but what you're going to do with it is a different problem. And that is you're going to formulate curtailment notices, perhaps. And I've discouraged you from doing that because water rights are very specific to location and to the individual situation. For example, the patent date, in my humble opinion as a lawyer who practices in the water field, gives you the date of vesting, not necessarily the date of priority. The date of priority is when settlement took place where use could have started of water on the piece of property. That's a riparian right. And it's not quantifiable. In an adjudication, you can quantify it, but it doesn't have a limit, except reasonable beneficial use. Okay. So giving you a quantity for a riparian right. No lawyer in their right mind representing a client like that could do that short of an adjudication. So some of the problems we have and you have and your staff has in reporting is trying to do something that we can't do.
Is that where you use the comment section?
Yeah, that's why we gave you an explanation. The comment section wasn't in the first round of the forms, but we submitted a standard explanation form with everything that we did in our office to you to explain that. And we talked to staff about it as well. So the priority date is not the data patent, but that establishes the vesting of the title to make that claim. So the priority date is different. The pre-1914 date, some drunken miner went up on federal land and diverted water to separate the gold from the gravel diggings or whatever. That establishes a pre-1914 use of water. There's a very complicated issue as to whether there's a priority for that right versus a riparian right and how it all works. And I'm not sure I've got a firm grasp on that. I looked at cases, but the law is yet to be completely clarified. Now, we also have filings, post-1914 filings in the Delta. Years ago when there was turmoil over how water rights were going to be treated and this and that, many of the more sophisticated people said, well, we better cover our bet. And they filed for appropriated rights from the board. So we have overlapping rights that we cannot unoverlap without adjudication and determining some of these issues. And it isn't because we're just trying to be obstinate. It's a real practical problem for us. Now, we are willing in the Delta, Central Delta and South Delta to work with your staff to try and sort this out. Now, there has been double reporting because we haven't been able to segregate it. And your staff doesn't like us to comment and say, well, these are overlapping rights, only count them once. Now, I'm going to try and do it for all of my future reports and try and get that sorted out so you don't accidentally end up with this complicated overlap of rights and a large quantity of water that is being criticized as being out there. Now, water rights law treated appropriations and filings with you people as a hunting license to go out and try and find water. So if somebody came in and said, hey, in a flood year there's water coming down the river, we want to try and get a permit to go out there and exercise our due diligence to perfect that right. So there's lots of filings. The two biggest examples are the State Water Project and the Federal Water Project. They asked for an extension from you for their due diligence. We objected to it, and I never heard from anything again. They still want to be out there claiming all this water that doesn't exist or isn't practical to capture. So it's those real problems that I hope you people will understand. We'll try and work with your staff in good faith, but to come up with a short time deadline and expect people to respond and fine them, to me, is bad. It's just not the right thing to do.
There's something in between open-ended multiple decades and the ability to...
Yeah, I agreed with you. It was yours.
We have the authority, as you can see from what we did last year, we didn't use it to the full extent.
Yeah, to me, you shouldn't be using the emergency authority to this. But I understand what people are saying.
Yeah,
and I just don't think
There's
that's the way to do it.
94% is a good number. And we saw the same thing with our partner agencies, with the water agencies last year. They would give a 66% response on basic information. And then when we required it with these uncomfortable enforcement provisions, we got 98%.
That's okay. You can get a gun, you know, and go out and illegally put a
Just
gun to
being
somebody's
practical.
head and said, I'm going to shoot you, and you may get some compliance. It's the procedural due process that you hear people talking about and the emergency authority to get at this. There's no question you can be effective with I'm going to call it an unlawful means. And I'm appealing to you that that's not a good way to do it. Now, I didn't file the suit against you on the emergency regulation, and I'm thinking of other litigation, not necessarily against you, but the state and the federal projects are saying things about the Delta, and all of a sudden they now claim they don't understand that there's water in the Delta all the time, and I've given you their admissions. If we can't win that one, I'm going to quit. But anyway, you're hopeful I realize that's the case. But don't forget, there are appellate courts, Supreme Court, and all of this and that. So you may not prevail in that regard. But I would urge you not to get into the detail of curtailment of water rights if it's possible. You have the bully pulpit. You have an ability. People pay attention to you. I mean, we have always paid attention to you. I paid attention to the chairperson's admonition that other people have submitted all their information about their water rights. I knew it was tough, but we lucked out and found a database that gave us a good bit of that information. But a lot of people don't have that luck. So anyway, I would appeal to you not to use the emergency requirement, to be flexible in dealing with the people with regard to the information. I would caution your staff, although they're all very competent and aggressive people, that jumping into the detail of curtailment of water rights is a sticky, detailed process. And so anyway, those are my comments, and I hope you don't require us to provide reams of information again on a very short timeline, because many of us lost our weekends and a lot of time, but we think we're happy with the success, and we do want to give you the information you need to do your job. So thank you.
I just have to jump in here and thank you for that, because I think your leadership has a lot to do with the high numbers that we saw.
I think my luck has to do
Well,
with it.
yeah,
because we
but even
found the
before you knew
database.
about that tool last year when we were here, you did say that you would comply.
Well, we want to comply. Why do we want to not comply with you guys? We've got so many people to fight with. Why do we want to fight with you?
I really don't want you to quit, because I just really enjoyed, I thought it was such a coherent description of the puzzle that's out there about the issue of overlapping water rights. And I thought your explanation was really easy to understand. It was a good teaching moment. Thank you.
Regular person. Mr. Erlewine, followed by George Hartman from Reclamation District 2030 and 2074.
Thank you. Good evening. Terry Erlewine, State Water Contractors. I just wanted to say that the State Water Contractors support the resolution. We actually think that you don't need the emergency basis or emergency basis for passing the resolution. We think you could do it under the your regular authority, but we support the use of emergency authority. We think that this is a good step towards providing additional information that's needed to administer water rights, and particularly towards protecting stored water, because we had some discussion of excess water. Over the last year, we had during the irrigation season when we were water short, it was project water that was going towards meeting all of the outflow and supporting a lot of the upstream use. So wanted to make sure that's on the record and reiterate that we are supportive of this resolution. Thank you.
Thank you very much. Mr. Hartman, followed by Jean Salesi. How do you say Jeannie because of the way it's spelled?
Hi, George Hartman, representing Reclamation District 2030 and 2074. It's late. Hello, everybody.
Hi.
Madam Chair, board members, I have two concerns. First, As some of you know, I'd really like to change this dialogue. I'd really like to see a different way of talking about these issues, and hopefully an effort that we're working on will make a dent in that and set a precedent. We don't know. We're still working on it. So I've got a couple of concerns. Number one is the attorney for staff. I'm sorry, I don't know your name, sir. You talked about how staff vets these complaints before it takes action. I don't think that's embodied in the regulations. I think that's an in-house safeguard that you have adopted to verify that a complaint has enough merit to warrant further action. Is that about right?
Andrew Tarianen.
I didn't know your name. I'm sorry.
It's not necessarily in the way you're putting it. Maybe the way I explained it wasn't quite the way it is anyway. An information order or even an inspection just on a complaint that comes in through the internet, let's say, by nature gets some vetting and some determination as to its efficacy. And those that have more get more investigation, and they all result in something, an investigation report.
Who makes that decision? Who makes the decision as to whether it has efficacy or not?
The staff that are
Under what guidelines?
under their expert opinion.
That is set by what? I mean, where can I find a written description of what qualifications they have to have in order to render an expert opinion?
Mr. Herman, staff does the best they can based on their experience and judgment. They don't chase every complaint because there's not time to chase every complaint. We're not funded to chase every complaint, so there's a certain amount of judgment involved. If you're asking for us to put out you're creating a giant mousetrap in which really nothing would ever happen, so I'm not quite sure.
Well, that'd be
what you're
okay with
trying to
me,
make.
but
It shouldn't be okay with you.
no,
Because
but
people have lived in this agonizing finger pointing for years and years and years, and maybe
I know.
some people enjoy living in it. I don't think you do.
I imagine you're getting to the suggestion that I think Jeannie Zalesi has in her letter to tighten up the language,
yeah. I think,
just so we can
I don't doubt
look
that
at something
staff,
more specific on what you're raising. I'm looking for that language here.
I had one more point to my
Sure, I'm
comment,
sorry.
and that is specific to the regulation and the information orders that would be issued under the regulation. Those orders, every order of the board requires findings
sure,
to support the order. Those findings in every case will describe both the evidence and the reason
sure.
for issuing the order. That's the safeguard. That I think is what you're looking for.
That's the consummate safeguard. What I'm worried about is Mr. Nomalini described to you the great luck and fortune that he had in finding a state lands database that has all the information that enabled his office and the engineers to really give you great compliance. And a lot of that involved my clients. They did an amazing job. But there was fortune in that. There was luck, but it was a burdensome task that without finding the database, I think would have been nearly impossible. And so what I'm worried about is the trigger is a complaint. Someone files a complaint, that's a trigger. The staff is the first level of safeguard. And this gentleman talked about how they make an effort to determine the materiality or substantiality of that complaint before it goes any further. Well, when it goes further and an informational order gets issued, it's like a very nice client of mine, a lady who is not in Central Delta, who operates a dairy whose husband passed away a few years ago, and she's doing it on her own, came into my office on March 1st with the informational order. And I had looked at the list attached to the order to see if her name was on it, and it wasn't, at least not alphabetically. Her deceased husband's name was on it, indexed by his first name, and I didn't see it. She came in with it and said, "What do I do?" She is not in Central Delta, she's in North Delta. And it was only because of all the work Dante and his folks had done, and Kelson Sinek and Brett Baker and on, we were able to get her information put together for her two points of diversion and be submitted to you. Absent that, she would have been in violation, and it would have been a very expensive burden for her to meet to ferret out the information that you were requesting. I'm concerned about the fact that there is no threshold for filing a complaint. Anyone can file a complaint.
Well, if I could,
Yes.
it seems to me that there are two issues. One is whether or not the language should be tightened up, and I would just refer everyone to Jennifer Spalletta has a suggestion on the first page of her letter, and then Jeannie Zalesi, I'm sure she'll speak to this, also different language, but language to tighten up the provision on the complaint. But I'm just wondering if you're speaking to yet a separate issue. We heard that there was just a lot of confusion when that order went out, and staff, after I think we had, I don't remember when the board meeting was, if it was maybe a month ago, staff was very responsive in putting additional information out on the forum so that people could comment. But this issue about finding out where you are on the list by first name, I just heard from a lot of people. They were very frustrated by this. And so I'm just, would like to hear from staff on, in the event that you go forward again with another order, what can you do to commit to work with stakeholders in advance so that they can see a copy of the form in advance and provide suggestions? Because I think a lot of the criticisms that came in were not just, we don't want to fill this out, but that they were frustrated. It was difficult for them to figure out how to fill it out and who it applied to and all those sorts of questions. So could you respond to what your plans are in the event that you issue another order?
Yeah, we're as far as the informational order form, we did provide a template on our website, which had all 3 pages outlined as to what the questions were supposed to be asked, and they could download that and just at their leisure go about filling it out, and then they can go to the actual form and fill it out.
Well, I'm referring to in the event that you do this again, what can you commit to work with stakeholders in advance so that they can see what you plan on having people fill out, so that they can make comments. You know, maybe it could be simplified, or you know, since they're out on the ground, they may see some options that you all wouldn't have thought of. And then the other issue that comes to mind is the website. I heard a lot of complaints about the website. It was too difficult for them to finally get to the place where they could get the information.
Yeah, it's on the first issue, I don't think management has any objection to providing the form in advance. I don't think there's a problem there. As far as the finding the link on the form, the hyperlink to the web form was referenced in the letter. So if they received the letter, the URL address was there on page 2. I think it was paragraph 3. As far as going to the website and finding it, yeah, we only had it listed on one particular area because at the time we were planning on doing a website revamp to a new format and tab style, and that never came to fruition. But when we did receive enough people commenting on the fact that the link on the actual informational order that we posted on the website wasn't clickable, we went ahead and made the adjustments, and then everything seemed to be fine at that point.
Member Diadamo, just to reference that we are doing an upgrade of the website now. The tab form that Brian mentioned is going to go live hopefully soon. We've just had to work it through all the programs that have drought activities. And the other thing is we are very happy to put out the form, and if there's a group of stakeholders that would like to provide input, that would like to sit down and talk to us about it, we're very happy to do that. It only helps us to do our job better.
Okay. Well, let me wrap up. I don't want to prolong this. I have 2 other concerns. One is a client in the Los Banos area I met with yesterday, who's 86 years old, knows all the folks down in that area quite well. His property abuts the California aqueduct, and he said, how do these people get away with pumping groundwater and pumping it, putting it in the canal and getting paid for it? Now, I'm going to dig into it a little further and find out what's going on, but as long as you're getting into abuse and reasonable or unreasonable uses of water. I've heard other rumors that that's happening, that people are selling groundwater somehow through some contrivance. I'd like to know more about that, and if I find anything, if there's materiality to it, I'll investigate it before I file a complaint. And the other thing is, one slide showed that it was costing $1,000 per report for public agencies to respond to your informational request. I think because there's no barrier to a person filing a complaint, if their complaint is found to be without merit, there ought to be some way to charge them with the cost of a person having to prove that they had the right all along. So I'll just throw the old English system, loser pays, something like that. So I think that's pretty much all I have to say, but I want to thank all the folks who helped us meet your order. They did a great job, and I hope you're pleased with it. Thank you.
Great, thank you very much. I know we'll hear from more speakers, but we do have some suggestions on ways to clarify the complaint language that might give people some comfort to allay their wildest fears about it, or a fear of abuse about it. So I just want to encourage you guys to think about which, because some of them sound kind of reasonable, some requires too much, but I want you to be thinking about that because I know we're going to be hearing it. I just want you to think about language, comfort language on that one. Because again, people do, they fear an extreme in the absence. I don't think you can button it down all the way, but some of the suggestions are pretty reasonable.
Yeah, the issues, is it true that with the development of the form that maybe we're refining that, and so future actions you feel will have resolved some of the concerns?
Yeah, and when we actually developed the form through stakeholder comments, we made some revisions and some updates, and we're continuing to refine it. So I imagine in the event that this were approved and we got the go-ahead to issue more informational orders, we would consult with them and hopefully get our IT department to put a more robust password system in place, because that was one of the chief complaints that they brought up. But yeah, we're continuing to refine it.
Thank you, Mrs. Zalesi, followed by Danny Merkley.
Thank you. Jeannie Zalesi, representing Banna-Carbona Irrigation District and Patterson.
I'm sorry, I always call you Jeannie. It's just the way it's spelled, Jean Zalesi.
It's, yeah.
You seem like, sorry.
Either way.
I do it wrong all the time.
And Patterson Irrigation District. And I, obviously my letter's on file. I just have two issues that I want to hit because that we think are the most important. And the first is what a lot of people have mentioned, and that is our fear of an unsubstantiated complaint, or I think, to me, more importantly, the other requirement of information being provided. Because to me, it's just an opportunity for abuse. The reason we're really concerned is because we saw what happened with the last information order that went out. And I won't belabor that. You've seen our petitions for reconsideration. But basically, you got a letter with no information and no substantiating information saying someone's stealing my water and I think they're in the Delta. And you send out 1,000 information orders from, you know, way south on the San Joaquin River all through the Delta trying to investigate that. We don't think that was sufficient information on which to make people do all that. So my language or Ms. Balletta's language, I think something saying that that information or the complaint needs to be supported by at least some evidence determined by staff to be reasonable is a reasonable requirement. And with all due respect, as your staff mentioned, if they do that anyway, then they shouldn't really mind if it's in the regulation. That would give us some protection, something to fall back on. The second thing that we're very concerned about is the expansion of the regulation. We know that you needed the information. I agree with everyone else. we didn't think you needed to do it by emergency regulation. We didn't think you needed to do it by regulation. We have been volunteering that information since early last year, saying that you needed that to make good curtailment decisions. And obviously you can see the impact that it makes, so we're glad about that. We're very concerned with the expansion because we think it goes beyond information that you need and beyond your jurisdiction. Two sections in the proposed regulation in particular expand the requirement to require information of compliance with transfer laws and information about transfers that haven't been approved by the board, and as staff in its presentation said, unverified or previously unnoticed transfers, and makes it sound like it's something bad. Those are transfers that are in compliance with law and outside of the state board's jurisdiction. And we have a serious concern that by requesting information on that, you are going to somehow insert yourself into the legality of those transfers. And obviously that's a concern. We acknowledge, while we don't agree with it, we acknowledge that the courts have said that the state board can determine the validity of a pre-14 right. We just don't think that that court case went further than that and said, and once you determine that validity, you can then regulate that right and tell them when they can change their place of use, purpose of use, and accomplish a transfer, because that's regulating that right, and you don't have that authority, and the law already provides the standard for that transfer, and the method to object is to bring a lawsuit on that. So that's our main concern with the regulation, is the whole issue of verifying those transfers that haven't been noticed or approved by the board. So that and clarification of the complaints or information is what we would request, and thank you.
Transfers, I'm sorry, you mentioned, Jeannie, you mentioned transfers a couple times here in your letter, so is there one code section in particular you're wanting us to look at?
Yeah, it's 879C1C and 879C2. There's two places in the regulation that transfers are mentioned. One is I think they can ask someone for information if they're basing their right on a transfer or a contract. They can ask for information on that. And then you can also, I believe in C, ask for information for any transfer that hadn't been previously approved or noticed by the board.
Right, and your concern is that we would then insert ourselves in regulating it.
That transfer.
I think the purpose is not to regulate it, but to actually understand the validity of the numbers we get from folks we do regulate, because we are getting information that someone says they got it from a transfer, and then we have no way of knowing what that transfer was. You guys can say it more concisely than I can.
Yeah, so
Problem as I understand it.
Yeah, the issue is that, you know, similarly to when we've sent a curtailment notice and then investigated, and the response is, oh, I'm using a riparian right for which I have never filed a statement.
That's totally different. We
know,
support that part of the regulation.
And so, but with transfers, there can also be a similar, if it's something that we've never heard of, then there's that same question of did somebody really do this? And so being able to follow up and say, okay, now who did you get, whose water right are you talking about? And being able to look at their water right and say things like, yes, it is for June. And yes, it is at a place where you could conceivably divert it. Here allows us to look at that and decide, is this something that needs to be investigated, or is this something that we just want to throw into the calculations of where the demand is on this stream system? Is it way up at the top? Is it down at the bottom?
Well, the information that the regulation says you can ask for is not narrowed to the way that you've just described it. Because if you said, you know, you have to provide us with how much you're diverting under that right And what right it is, I mean, that's different. But it goes way beyond that. It says we can ask for all information upon it, and we can ensure that it complies with transfer criteria. That's a whole different level of analysis that is not required under the law currently.
Could you
And that's
recommend
where-
some language, as you did with
Well, our recommendation would be
Well,
taking it
yeah,
out.
No, but if we're going to move forward with trying to compile the information for a potential curtailment, I could see why we would need that information.
Well, you know,
So-
with all due respect, I think it's already encompassed in what you have. I'm just thinking of some of the transfers that I know are going on. You are asking for, already under the reg, you would ask for how much they're pumping every month. So you have the amount they're pumping. You know that they're curtailed. So everything they're pumping has to be under that transfer that they're talking about. You can obviously ask them who the transfer's from under your existing regulation. You can call that other diverter and say, did you transfer to so-and-so? And you know what that other diverter's right is because you can ask for that information as well. So all you need is the total information. If that pre-14 user has a right to pump 200 and there's 50 being pumped at both points of diversion, you have enough information right there. And that's all available under your existing regulation. So you don't really have to expand it to say we need all the information about your transfer so that we can go through and make sure it complies with transfer criteria. That's a whole different level. So I think you already have the ability to get the information that you need to verify. So I can't provide you language other than what's already in there.
We're looking at it.
No, I'm
mean,
looking
certainly-
at it, 'cause my understanding is, because we had people who would say, I got it from so-and-so, but we had no ability to get any awareness of whether so-and-so transferred the water and fallowed or did something, reduce their use by the amount they transferred, so you're just trying to make sure the math adds up.
We are definitely intending to leave that in, but whether the language specifically of C2 regarding compliance with transfer law could be narrowed, that's what we're trying to decide right now, because what you're talking about, the existence of the right, whether it was in fact transferred, that goes to whether there was an unauthorized diversion, not regulating a pre-14 or riparian water right, but we're trying to see, we're working on that right now.
Okay, think about it.
Yeah, because I think there's a little bit of to assume that we can, that someone says, oh, I'm using water transfer for so-and-so means that we should immediately go investigate so-and-so because we can assume that there's an unlawful diversion. I think that's the kind of logical leap we were trying to avoid having to make every time. But I think that it is possible to get at everything we're trying to get at using more words that describe exactly the type of information we're looking for, rather than just sort of the pithy, was this transfer okay?
Yeah.
So I think we'll go for more detail and then run something by you guys.
Think about that one. Mr. Merkley, followed by Deirdre Desjardins.
Thank you, Chair Marcus, members of the board. Danny Merkley with the California Farm Bureau Federation. I'm going to go real quick because I'm going to repeat some things that you've already heard. But I want to start with, if this is truly about collecting data for managing the system better, then every effort needs to be made to convey that in a clearer and better way. I thought that was a very good point. It was up on the PowerPoint earlier by staff, and that's something that isn't necessarily conveyed to folks in a clear way. And quite honestly, when this stuff comes, it comes across to people that are out there in a very threatening and scary way.
People read the most negative thing into something unless...
So anything we can do to help that tone in letters and notices like that, but then also when staff is reaching out to them. And as we all know, we're human beings, and some of us are better at that than others. And some of us are better some days than other days, too. Moving on, the information requests as spelled out in this seem to be without the same careful triggers that were in the emergency regulations last year. And that's a concern for us. It seems to be almost asking for information without cause. So that's a concern and something, we weren't real thrilled with the emergency regulations last year. We're even more so concerned with what we're seeing this opening up and the changes this year. Also, and this, I let in this a little bit, please understand the unfamiliarity with this stuff for some of these folks out there. I mean, you heard stories about some of the older ones and folks that really don't understand this stuff. We're dealing with that every day with our members. I'm getting calls, far more calls than I can handle. I probably got a bunch today, but I don't know because I've been here most of the day. So that's important. It's, for the most part, you're looking at very honest, hardworking people that are dealing with Mother Nature in a way that most of us have never had to deal with it. And they got to get it done or it doesn't get done. And there are no excuses. Maybe you can make a little excuse to the water board or ask for a little forgiveness or a little extra time to get something done. And if you're showing good effort, that works. But with Mother Nature, it doesn't work. It doesn't at all. Especially if you have a dad you're working with on the ranch. But I digress. Also want to be real clear about the ask, why we're asking for this, a little bit what I said earlier, and what we're asking for, so that people really do understand. And I think that goes a long way to helping people realize that, well, this is actually good information. It's going to help us with the curtailment notices so that we're not curtailing uses that aren't necessary. And that's not necessarily put out there. And I want to, I was real concerned about the slides I saw talking about the fiscal impact. Maybe I missed something and maybe I glazed over for a minute, but it was talking about the fiscal impact to local governments and other governmental agencies. There's a huge fiscal impact and resource burden on a lot of these folks in trying to get this stuff figured out, because it's information that they assume they had. Whether that's correct or not, it takes time for them to go back and research this. You heard some of this from previous presenters, and that's a real challenge. We have worked, Farm Bureau has worked very hard to try to help folks with the information, to help them comply. There's a number of things that have passed, laws and regulations that we were opposed to, we didn't like, but when they pass, we're out there trying to help our members comply. Every time a curtailment notice went out this last year, that very same day, we sent information out to all of our members immediately to help them understand what was going on, to help them be in compliance. And we're continuing to try to do that, but we need a little help helping you, if you will, with that, and helping our members be in compliance with something that's new and difficult and very hard for them to do. I'm going to end there because the buzzer just went off and it's late. Thank you.
Thank you very much, and thank you for the help when that happens. We actually do need all that, the help we can get that way.
Thank you. I know it's very...
One second. After you will be Lucianne Phillips.
Thank you. I know it's late. I just had an observation about the Delta curtailment generally. And that's, I know the method that DWR is using for the curtailment analysis, and they're not considering, there's a 55-year-old requirement for the Bureau of Reclamation to provide water for salinity control in the Delta. And the board has required that since D990 was instituted. And I just want to this is fundamental, and this is what they said. Throughout these proceedings, the Bureau's representatives have consistently affirmed their policy to recognize and protect all water rights on the Sacramento and in the Delta existing under state law at the time these applications were filed, including riparian, appropriative, and others. Unfortunately, these rights have never been comprehensively defined. It is imperative, therefore, that the holders of existing rights in the United States reach agreement concerning these rights and the supplemental water required to provide the holders with a firm and adequate water supply if a lengthy and extremely costly adjudication of the waters of the Sacramento River and its tributaries is to be avoided. And as we know, they did reach that agreement with the Sacramento settlement contractors, but not with the users in the Delta. Just a sec, skipping to, there was a specific term included in the contracts. The State Water Rights Board reserves continuing jurisdiction over permits issued pursuant to applications 5625, yada, yada, until March 1st, 1964, or such additional time as may be prescribed by the board for the purpose of formulating terms and conditions relative to salinity control in the Sacramento-San Joaquin Delta. Permittee shall, on or before 1962, and each 6 months thereafter, submit to the board a written report as to the progress of negotiations relative to agreement between permittees and the state of California and/or the permittee and water users in the Delta and in northern Contra Costa County. They're not submitting these progress reports, and it just seems like cooperative efforts have broken down. But I just wanted to urge the board to think about this in the context of this curtailment proceeding, because this was an interpretation of the area of origin rights by the board when they initially issued this permit. I calculated that there was needed 2,000 CFS of supplemental water in June. 1,500 CFS came from the Bureau, and that was exactly the amount that their engineers estimated they would need for salinity repulsion back in 1960. It may not be that there's any extra water for salinity, but are we going to shift the burden for salinity control onto the riparian users or not? So, thank you.
Thank you.